Good evening, everyone. So I think we're going to get started now as more people join. It's really great to have so many people joining us tonight for tonight's panel and discussion on the serious problems that we're facing with Bill C-2, the so-called Strong Borders Act, and to talk about what we can do to stop it. My name is Tim McSorley. I'm the National Coordinator of the International Civil Liberties Monitoring Group, and I'll be moderating tonight's discussion. The ICLMG is a coalition of 44 Canadian organizations ranging from a wide range of sectors that works to defend civil liberties from the impacts of national security and anti-terrorism laws. We're one of tonight's co-organizers, along with the Migrant Rights Network, OpenMedia, the Canadian Council for Refugees, and the Ontario Council of Agencies Serving Immigrants. Tonight I'm joining you from Ottawa on the unceded lands of the Anishinaabe Algonquin people. We pay respect to the Anishinaabe, who are the original guardians of this land. We thank them for their stewardship of this land, and we acknowledge their long-standing relationship with this territory. We pay respect to all Indigenous peoples in this region from all nations across Canada who call this land home. We also acknowledge and remember in our work that when we talk about the impacts of border restrictions and national security, that has been First Nation, Métis, and Inuit people who have borne the brunt of these regimes since the arrival of the first settlers and the founding of Canada. Tonight, we have four really excellent panelists joining us to guide us through Bill C-2 and how we can work together to stop it from progressing and becoming law. I'll introduce them more fully later, but we have Sarom from the Migrant Rights Network, Adam Sadinsky from the Canadian Association of Refugee Lawyers, Kate Robertson from Citizen Lab, and Matt Hatfield from OpenMedia. We're also very lucky to have with us other area experts who have been working against Bill C-2 and will be helping to answer questions as they come up through the night and during the Q&A. They are Debbie Owusu-Echa, Director of Policy and Advocacy at Action Canada for Sexual Health and Rights, Ashlyn Jackson, Staff Policy Counsel at the BC Civil Liberties Association, Julia Sand, a lawyer working in human rights law and policy at Amnesty International Canada, and Aisling Bondi, President of the Canadian Association of Refugee Lawyers. A quick word on the plan for tonight. After a short intro, we'll hear from all four of our invited speakers, who will cover specific parts of the bill and finish with how we can mobilize against it. Then we have a bit of a surprise. We've set up an action tool that we can all take advantage of during the webinar. It's a click-to-call tool that Sarom and Matt will explain more about later on once we get there. After that, and as we start making the calls, we'll also move on to the Q&A and discussion. Tandis que le webinaire sera en anglais, nous vous invitons de poser vos questions en français aussi, et nous allons les traduire pour les panélistes. For questions throughout the evening, we invite you to put questions both in the chat as well as in the Q&A box. Questions you'd like answered at the end of the discussion should especially go in the Q&A, please. However, we'll also have our invited experts who will be able to provide answers in the chat and provide answers to questions that come up throughout the evening too. Once we get to the Q&A, we'll be able to hear more from both our panelists as well as the invited experts. We encourage you to use the chat throughout the evening, not just for questions, but also to share where you're joining us from, if you're with any organizations, how you'd like to get involved, and more. The webinar is also being live streamed on YouTube. Hi to everyone who's joining us over there. And the recording will stay up on YouTube afterwards, so you can catch up if you need to leave early or share it with your friends and in your networks, which we really encourage you to do. We'll also be sending a follow-up email to everyone who registered with a link to the YouTube recording, all the resources that are brought up tonight and shared tonight, and even more. So keep an eye out for that over the next coming days. I think that covers all the basics, and so now just a really quick intro on why we're here tonight. As you know, Bill C-2 was introduced early this summer on June 3rd. It was the very first bill of this parliamentary session and from this new government. After running a campaign based on so-called elbows up, and Mark Carney trying to distinguish himself from the Trump administration, this bill really betrayed his and his government's true colors. It's an omnibus bill of more than 120 pages that proposes to make vast changes to a wide range of existing laws and introduce new ones. This includes troubling changes to the Immigration and Refugee Protection Act, the Criminal Code, and the CSIS Act, all the way to the Canada Post Corporations Act and rules governing the Coast Guard. The threat this bill poses is in line and in some ways worse than what Stephen Harper's Conservative government provided in Bill C-51 that so many people across the country mobilized and organized against back in 2015. As our speakers will cover tonight, the bill is a dangerous move that is anti-privacy, anti-refugee, anti-migrant, and places all of our rights at risk. It's imperative that we fight back against it. The good news is that over the summer, more than 300 civil society groups called for the bill to be withdrawn, and dozens of those are now members of an organizing network. Even more importantly, we have hundreds of people on tonight's call to learn more about the bill and wanting to organize against it. So with all that said, we'll move on to our first speaker, Sarom Rowe. So I'll just stop sharing this. There we go. And I'll introduce Sarom. Sarom Rowe is a coordinator with a migrant rights. I'll start that again. Sarom Rowe is a coordinator with the Migrant Workers Alliance for Change, MWAC, a workers' organization with a membership of migrants in farm work, care work, and low-wage work, which includes international students, refugees, and undocumented people. MWAC provides direct services and campaigns for changes to federal. MWAC provides direct services and campaigns for changes to federal and provincial policies. MWAC is a member of the Migrant Rights Network, which is the largest cross-country coalition of migrant-led organizations. Sarom will be speaking about the overall context of this bill and its impact on migrants. Welcome, Sarom.
Thanks, Tim, and good evening, everyone, from wherever in this country you're joining us from. We're here to talk about Bill C-2, of course, and at the Migrant Rights Network, as well as the more than 200 organizations that have signed a joint statement calling for the full withdrawal of Bill C-2. We have identified this bill as being cruel, useless, and dangerous. I mean, it's cruel in its treatment of people without permanent resident status, of migrants, of refugees, of undocumented people. It's not actually going to be useful in making any of us, migrants, citizens, permanent residents alike, any safer. And it's dangerous in the sweeping powers that it will give the federal government. And in that, the state of unrest that it sows in all of us. This is a time where more than ever before, we need to be united. And that's a little bit about what I'm going to be talking about and what my fellow panelists will be talking about as well. I was reading, I opened up the news today and, on both sides, East and West Coast, there are massive wildfires. There are hundreds of wildfires going on in the country, and in Nova Scotia, they're saying that it's out of control, right? We're in a moment of massive climate catastrophe. At the same time, we're 1 week away from returning for so-called back to school, back to business. Many of you who may have kids are going to be going to school. And the Breakfast Club of Canada has said that this year, more students are going to schools, elementary, middle school, and high school, hungry. Universities and college students are also feeling the pinch, and they're worried about how they're going to pay for tuition and afford groceries and rent at the same time. This is a time of massive economic downturn. And while so many of us, so many working people in this country are going hungry, struggling to make ends meet, we are being told that the wrong set of people are responsible for the crisis. For the past 2 years, it's migrants, it's refugees, it's undocumented people who have been scapegoated for the housing and affordability crisis. It's not the migrants who are taking jobs, it's actually these big corporations and measures to cut public service positions, to gut public post-secondary education and healthcare, to chop off parts of the institutions that we love so much and sell it to be privatized, right? But we are all being told in the media, even in our communities, that it's somehow the migrants and undocumented people who are responsible. And this is simply not true. That has been happening for the past 2 years, and it's within this context that Bill C-2 has that Bill C-2 is following. I want to also just talk about how in this moment where many of us are feeling the pinch, Canada's also reported that the highest income households actually made more money this year than they did last year, and that it's outpacing the growth that the lowest income households have made this year. So what is this showing us? It's saying that the rich are getting richer in a time where there is economic downturn, where there is economic crisis. And so rather than blaming some of the most vulnerable and marginalized people in our society, we are being told these myths as a way to divide and distract us. And part of the work that it'll take to get this egregious bill withdrawn, this bill that doesn't serve anybody's interest, is to unite and actually hold the real people responsible. So I'm just going to quickly talk about what the bill does. So one, it has some key changes that affects everyone. So Adam's going to talk about refugee protections that are being rolled back. There's also a massive expansion of what's called governor and council powers. And this is essentially a cabinet. It means that cabinet will now have this kind of sweeping authority to suspend, cancel, or terminate entire categories of immigration or status, all in the name of so-called quote unquote public interest. And I want us to really think about in whose interest it serves for the government to have these kinds of sweeping powers. These massive changes can be made overnight without debate or oversights. This means that, permanent residency can be rescinded. Orders that entire groups of study permits from particular countries can be canceled. All of this can be canceled en masse, and that's going to worsen the exploitation that migrant and undocumented people already face. We have to remember that in any society, if one section of working people, if one section of our communities, if one section of our society is pushed down, it affects all of us. The pandemic showed us so clearly that an injury to one is actually very much an injury to all, right? And when there is one section of people in our society who are made to be vulnerable, it lowers the floor for all of us in a time where we should actually be working together to raise the floor. This is what's also called an omnibus bill. Mark Carney, Prime Minister Mark Carney, as Tim said, was elected on a platform where he's so-called elbows up Canada. He said that Canada is not like the United States, said that he is not like Trump, and yet the first bill that he has tabled is one that is exactly Trump style, and in fact, worse in the omnibus aspect of it. It means that in this bill, there are many things that are buried in, including, provisions on so-called lawful access and surveillance that allow the state to, erode privacy, and we're going to be talking about that later today. But there's also massive kinds of data sharing. These kinds of omnibus bills are alike to another bill that has actually been passed, like Bill C-5, and this is a bill that is to so-called nation build. But essentially what it is that it's a bill that allows for the deregulation of important oversights. Already, Indigenous groups and climate groups have come forward saying that this kind of centralization of decision making when it comes to bulldozing on their lands to ensure that there are important labor and environmental regulations are suspended will hurt us all. And that is the context in which this liberal government is operating. Bill C-2 specifically also strengthens the power of the federal government, of cabinet, to make these decisions. But I want us to all remember that right now there's already been 2 years of anti-immigrant policies that have already come down the pipe. Last year, the federal government slashed permanent residency programs. It also made it much more expensive for international students to come here on study permits. And now, again, they're squeezing more tuition and more money from these students who are coming from working class families in the global south. They've also made it impossible for migrant workers to bring their families and instituted family separation policies. And right now, because the federal government has already slashed permits and gutted permanent residency programs, every day 3,000 people are having to make the very difficult decision of staying or leaving the country that they have built their homes in because their permits have expired or will expire. In 2025 and 2026, by design, the federal government is letting the expiration of 1.2 million permits to happen. These are some of the people that I organize with, that I have who are in my community. They're also in your communities. They're also your friends. They're also your coworkers. Institutions like universities and colleges, as well as important long-term care facilities and hospitals, are already talking about how they are deeply affected by the knock-on effects of these changes to immigration policies that have already come into effect. There's a so-called shortage of labor in certain sectors like healthcare, like construction, where actually we need more homes to be built. And yet the growing number of workers who are in those areas are not being allowed to stay because of these draconian immigration policies that have already made it difficult for migrants to stay here. Canada's also deporting people every day. Just a couple weeks ago, one of our members, a reverend who has served thousands in her community, was deported, and so were her 2 young children. This is not the kind of country that any of us want to live in. And it's within this context of 2 years of anti-immigrant policies that have emerged from the scapegoating of migrants for housing and job crises that are in fact manufactured by the corporate elites, by housing developers, by grocery chains and monopolies, that Bill C-2 is coming. This is a fundamental attack on the rights of everyone in Canada. And I'm seeing so many people in the chat already talking about how Canada is is richer because of our communities and of the migrants who make up our family and friends and neighborhoods. Now, I want to just quickly talk about why it matters that the governor and council powers are set to be expanded. This is a political decision. So it means that immigration policies will not have to be debated or scrutinized or even amended. Bill C-2 can sidestep this altogether, and it's a massive concentration of power in the hands of cabinet. You may have heard Prime Minister Carney already talking about cutting red tape. And what that means is that's actually counter to the public interests of people like us, of working people in the country. This kind of ability to suspend and terminate entire immigration categories of work permits, study permits, refugee protections, and even permanent residency applications has disproportionate effects not only on racialized people, but also on women and trans and queer people. And it's also collective punishment, right, for these people, because again, this power gives the federal government to cancel and terminate en masse in big groups, and it denies people individual appeals processes. We're already seeing right now the amazing ways that many of us are practicing this right that we value so deeply in democracy, which is the right to say no, which is the right to refuse, right? When the boss tries to mistreat us, when lowers our wages, are not ensuring health and safety standards, we as working people have long fought for this right to refuse unsafe work, right to refuse work altogether until we get the fair conditions that we deserve. And it's in the time where we are feeling this kind of contraction that it is so important for us to collectively refuse and say no. Because of the nature of how um, this government has been implementing divide and distract policies, the way to counter that is to unite. Instead of working only and organizing only in the different issues when it comes to privacy or civil rights or labor or immigration or gender-based violence issues, queer issues, instead, when we're seeing that they're coming after all of us, then all of us must stand together and unite to call for this bill to be completely withdrawn. Um, there are two actionable ways that we can do this. One, Matt's going to walk us through a number of different steps that we can take action together. And the other way is for us to have the conversations at the kitchen table, at the dinner table, when we are passing by with our coworkers at the water cooler or in the hallway to talk about how this actually is not good for any of us, and that there is a way for us to completely build our power to do this thing, to do this amazing thing, to refuse this attack on all of our rights. And so I am seeing how, with the defiance of the legislation, the work order that was issued by the federal government, how CUPE, they said no, they defied the order. In that spirit, in carrying that spirit, many cities across the country in Canada will be gathering on September 20 to call for a united front to say that actually Prime Minister Carney's honeymoon is over, and that we need to unite struggles for migrant justice, for Indigenous sovereignty, for anti-war, and for economic and climate justice together to say people first, and we refuse to be divided. So I'm really looking forward to getting into more details about what this bill is, what we can do together, and really fighting to get this bill withdrawn before Parliament is set to return in a couple weeks. Thank you.
Thanks so much, Sarom. That was really excellent, and thanks for running down how the political context and how it's clearly going to have a negative impact on migrants and others in Canada, and just how dangerous the bill is, but also what we can do to fight back against it. So I'm just going to share my screen here, and we'll be moving on to our next speaker, who is Adam Sadinsky. Adam is a refugee lawyer at Silkoff Schachter in Toronto. He represents refugees and migrants in all types of refugee and immigration applications with a focus on litigation, refugee claims, and inadmissibility. In addition to his legal practice, Adam is co-chair of the Advocacy Committee of the Canadian Association of Refugee Lawyers and has been an active media voice on issues affecting refugees and migrants, including advocacy around Bill C-2 and its impact on access to protection in Canada. Adam will be sharing with us analysis of how Bill C-2 will be impacting refugee rights in Canada. Welcome, Adam. I'll just stop sharing and we'll move over to Adam. Take it away.
Thanks so much, Tim, for the kind introduction. It's really an honor to be speaking on this panel this evening with experts from so many different areas talking about this bill. Good evening to everyone watching from across the country. I'm here in Toronto, where I acknowledge I'm on land. The land I'm presenting from is traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabeg, the Chippewa, Haudenosaunee, and Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis people. I speak to you on behalf of the Canadian Association of Refugee Lawyers, a not-for-profit organization dedicated to advocating for the legal rights of refugees. Our membership includes approximately 350 lawyers, academics, and law students across the country. So I want to build on, Sarom gave us the broad political context that Bill C-2 is coming to us in. And she mentioned that this is an omnibus bill, amending 14 different laws. And even within each of those different amendments, there are multiple changes. And I'm going to focus on the Immigration and Refugee Protection Act, and that's no different. But in my time this evening, I want to drill down on one critical element of the bill, which is a new form of ineligibility for refugee claims made by certain categories of individuals. So I acknowledge that the audience tonight are not all refugee and immigration practitioners. We all have different familiarity with the law and how it works. So I'll start off with some basic background and then delve into the details of what these changes are and how they impact refugees and migrants. So anyone who makes a refugee claim in Canada, and when I say refugee claim, this is the same as asylum. In Canada, we call them refugee claims. But anyone who makes a refugee claim in Canada must pass a preliminary eligibility determination before their refugee claim can be heard on its merits by the Immigration and Refugee Board, the specialized tribunal that deals with these issues. The Immigration and Refugee Protection Act, the IRPA, it already contains 7 different categories of ineligibility, which are reasons that someone might not be able to progress in their claim to the Immigration and Refugee Board. Some of these things include sort of serious matters like security concerns, violating international and human rights, but other ones include somewhat more administrative issues, like having made a claim for refugee protection or asylum in one of the Five Eyes countries. So those are, in addition to Canada, the US, the UK, Australia, and New Zealand. So there are already a number of categories of people who are already ineligible to make refugee claims in Canada, and Bill C-2 would add 2 more. So what does it mean for someone to be ineligible? What it means is that once that ineligibility decision is made, they're taken out of the stream that ultimately culminates in a hearing at the Immigration and Refugee Board. And instead, that person's fear of returning to their home country is going to be assessed in a distinct process called a pre-removal risk assessment, a PRA. And unlike the IRB, which holds full hearings where refugee claimants have the opportunity to make their case to a board member deciding it, the vast majority of PRAs are determined on paper by an officer employed by Immigration, Refugees, and Citizenship Canada, IRCC. Some PRAs have mandatory hearings. Those are for the Five Eyes cases that I mentioned earlier, but the vast majority do not. They're decided on a paper record, typically containing some forms, an affidavit from the applicant, and supporting documents. So these are very different systems, and it's a big deal if someone's claim is taken out of the refugee stream and put into the PRA stream. So that's the background. That's what exists prior to C-2. Now on to this legislation and what it proposes. So this proposed legislation would create 2 new categories of ineligibility. So 2 more groups of people who would only access that paper-based PRA system rather than a full-fledged IRB hearing. The first category is people who crossed the Canada-US border irregularly and avoided detection for 14 days. So this is an attempt by the government to close an alleged loophole in the Canada-US Safe Third Country Agreement, which was amended in 2023 to prevent refugee claims by individuals who crossed into Canada irregularly, so not an official port of entry, and are apprehended or file a claim within the first 14 days of arrival. So currently, as it stands, if a person enters irregularly and they're here for 14 days and they're not apprehended or they don't file a claim, then they can go ahead and make a refugee claim in Canada and go through the usual process. This bill would change that. Someone, even after that 14 days, they would only have access to the PRA. The second category would include anyone who entered Canada after June 24th, 2020, and then made their refugee claim more than 1 year after their original date of entry. So to put a finer point on that, the moment someone enters Canada for the first time after June 24th, 2020, a clock starts ticking. And that clock never stops ticking, even if they leave Canada. So if a year has passed from the time that clock started ticking, and a person then makes a refugee claim more than a year later, they're again not, if this bill passes, not eligible to access the Immigration and Refugee Board, they have that paper-based PRA. So why is this an issue? It should seem pretty obvious that a PRA is a far less robust risk assessment than a refugee hearing. It happens on paper rather than in person, and it shuts off a claimant's ability to provide oral testimony. And that's often very valuable in a lot of claims that we see as practitioners, where there may be something in a claim that to an uninformed observer may seem a little odd, it may seem inconsistent, it may seem odd to our particular lived experience as Canadians, but it might be easily explained by the claimant. Oh, why did you do this? Well, I did this because X, Y, Z reasons. These are my experience. But that may not have been in the initial documents that the person provided because they may not have anticipated that question. But the hearing allows people to address issues, to address questions that the decision maker has, and then to alleviate any concerns that they might have. In a paper-based PRA, that opportunity doesn't exist in the vast majority of cases. The IRB, the Refugee Board, also has procedural safeguards and guidelines that guide decision makers, including when they're dealing with claims involving gender, sexual orientation, claims made by unaccompanied minors, and others. PRA officers don't have these same guidelines. And then, once a decision is rendered, the regular refugee process and the PRA process diverge even more greatly. A negative refugee decision made by the board can be appealed to the Refugee Appeal Division, which is another division within the Immigration and Refugee Board. And the vast majority of cases that are refused have access to that appeal division. And then those decisions can be reviewed by the federal courts. And those corrective mechanisms are in place because humans make mistakes. They're safeguards that ensure that decisions are rendered in a legal, reasonable, and fair manner. And the IRPA, the Act, acknowledges that by preventing removal of most failed claimants while they make their way through the appeal process, with some exceptions. Why? Because people make mistakes. And we don't want to remove someone to a place where they fear persecution on the basis of one individual decision maker's potentially faulty decision. Now, what happens to someone in the PRA process, our ineligible category? Well, they can only seek judicial review in the federal court. So there isn't that appeal process. It's a judicial review, which is not exactly an appeal. But I'll spare you the greater details on that in Canadian administrative law. But what's important is, while the court considers the merits of the judicial review application, the individual is not protected from removal to their home country. And to stave off removal, that individual has to take another step and ask the court to issue a stay of removal, which is a highly discretionary remedy. So these are very different systems, very different procedural safeguards, and individuals who are in the PRA process have a much greater chance, ultimately, of being removed to a place where they face persecution, sometimes without a hearing. So why is the government doing this? They seem to be responding to a couple of different things. One is an increasing backlog of claims at the Immigration and Refugee Board, which stands at around 250,000 claims that are still waiting to be heard. And that is a problem. The second issue is a fear, overblown, that international students without a path to permanent residence will take advantage of the refugee system and try to remain in Canada with so-called fraudulent claims. Again, an issue, but very much overblown. And neither of these goals is necessarily problematic, assuming that A, it was that easy to assume that a claim is fraudulent simply because someone came to Canada more than a year ago or crossed into Canada irregularly, or that the proposed solution would work. But let me give you some examples of some of the people who will be caught by this one-year bar. And I'm guessing and I'm hoping that this is not who the government had in mind, and that eventually, first of all, this bill will be withdrawn. And even if it's not going to affect people like this. I recently worked with a client from Sri Lanka who came to Canada over a year ago for a birthday party. At that point, he had no fears of returning home. And he did. He went back to Sri Lanka. But once he returned, he started to face problems due to his ethnicity and his political opinion. But he had a visa to come back to Canada, so he did, now with the intention of claiming refugee protection in Canada. But because that clock started ticking when he came for the birthday party, and more than a year has passed, should this bill pass, he's stuck with the PRA, and it operates retroactively to June of this year. Other people may have been afraid when they left their country, but they had other options to stay in Canada that have now evaporated. Consider a lesbian woman from Uganda who got a study permit to do a 3-year college program in Canada. She saw promises from the Canadian government that if she studied here, she'd be able to get a post-graduation work permit, a job, and ultimately be able to apply for permanent residence. This is what was advertised to people. But as Sarom mentioned, last year, the government really closed a lot of permanent residence programs and very much increased the bar that most people would have to meet in order to reach those. So a lot of people who were sort of sold that ultimately false bill of goods, they thought they were going to have a pathway, but now they don't. And some of those people have a fear of returning back home. So back to this example, this person, she was here, she studied here, she attended Pride events, she posted about her sexual orientation and a relationship on social media for the first time, something she couldn't do back home. But now she's stuck. She didn't have to make a refugee claim before because she had another way to get permanent residence through established economic and educational pathways. She wanted to do things, quote unquote, the right way, the way the government wants people to make refugee claims. But now she can't. And the only way to ensure that she doesn't go back to Uganda is to make a refugee claim. But she's barred from that too. One last one. Someone comes from a country, she doesn't speak English. She's fleeing her abusive partner, came to Canada on a visitor visa. There's a lot of internalized stigma. She's reticent to talk to anyone about her experience back home. She comes to Canada, she's here for 6 months. She extends her stay as a visitor legally, and she's referred to a therapist who helps her work through her trauma. And then she learns about the process of making a refugee claim, but she can't afford a lawyer because she doesn't qualify for legal aid. She scrounges up the money, whatever she can, to afford a lawyer. But by now, when the claim is ready to file, it's been more than a year. Sorry, PRA for you, no refugee claim. For each of these examples, the timing of when they initiated their claim has nothing to do with the merits of that claim. But if this bill passes, none of those people will get their days in court. And the amendments will not even affect the backlog of claims in the system as a whole. The government's playing a shell game, simply moving the backlog from the IRB to IRCC officers. And unless the government invests heavily in hiring many, many new IRCC officers, that same backlog that lives at the board is just going to live somewhere else with IRCC, moving the backlog from one place to another. And many people who have tried to sponsor their families or apply to bring dependents of permanent residents over will say that those backlogs are already very long. And it'll also affect the federal court. As I noted earlier, PRA applicants must resort to seeking stays of removal by the federal court to ensure protection from removal back home when challenging a negative and often flawed decision. But the court itself is overburdened by its caseload, and the Office of the Chief Justice has suggested that any increase of work for the court should be accompanied by an influx of resources in the form of new judges. In reality, there are different ways that the government could have gone about achieving this goal. Different programs they could have initiated within the Immigration and Refugee Board without resorting to legislation. One of which, and all of these Carl has proposed to the government as recently as this past February, one would be to pull people who are working in certain in-demand industries out of the refugee queue, to regularize them and give them a pathway to permanent residence, because they're already living and working in Canada in valuable industries. And they don't need to be in the refugee queue, taking up those spaces where the board can consider other types of claims. So we're so glad that all of these organizations have come together to fight against this bill, for it to be withdrawn. or for it to be seriously amended if withdrawal is not going to happen. And so hopefully I've shared with all of you some of the issues with with this particular immigration side of the bill. It's certainly not the only one. We have also concerns about privacy aspects and how those are going to be incorporated both in immigration enforcement and elsewhere. And my colleagues on the panel are going to talk about the privacy issues as well. So I look forward to engaging with you all in the Q&A, and thanks again for those who are organizing the panel and for having me on the webinar.
Thanks so much for all that, Adam, and for really clarifying and describing the really problematic limits that the Canadian government's looking to bring in on refugee claims, and also clarifying what the real human impact of it and what we'll need to do to fight back against it. Just before we move on to the next panelist, I just want to share a reminder that you can ask questions both in the Q&A box. So that's at the bottom of your screen where it says Q&A. You can click on that to share a question or put it in the chat as well. We won't be taking questions live, so if you've raised your hands, we won't be going to you. But we ask that you put your comment or question in the chat or in the Q&A box, and we'll get back to you. Thanks. So I'll just share my screen again. There we go. And introduce our next speaker. Next, we'll be hearing from Kate Robertson. Kate is a senior researcher at the University of Toronto's Citizen Lab. Her research explores the intersections of law, policy, and technology. She has published human rights reports on emerging surveillance technologies and has represented public interest organizations in digital rights cases before the Supreme Court of Canada. She draws on former experience as a clerk at the Supreme Court and subsequently as a criminal lawyer in Canada's justice system. Kate will be covering the key privacy, surveillance, and related police and intelligence agency powers being granted in Bill C-2. Welcome, Kate. Thanks for being here.
Thanks so much for having me, Tim, and for the really important remarks from my colleagues so far on today's panel. I'm going to jump into situating my comments on C-2 in this area, and there are no doubt very many, and other experts have raised important considerations that I won't even have an opportunity to get to because the list is unfortunately quite long. As Tim mentioned, I'm a researcher at the Citizen Lab, which studies from an interdisciplinary perspective the intersection of information and communication technologies, human rights, and global security. And in the last few years, I have been examining the role of borders in law enforcement surveillance and cooperation mechanisms that are being used and negotiated internationally. And I think that I just want to zoom out to provide a little bit of that context because it informs what we're seeing in C-2. To a growing extent, we are seeing new ways in which borders are being exploited to the detriment of international human rights protections in transnational cooperation mechanisms. This might include outsourcing surveillance practices to authorities in other countries with lax privacy standards in ways that circumvent domestic laws in a state, or outsourcing to regional or international cooperation frameworks that are less accountable to state-level laws or even international human rights treaties, such as with Interpol, in ways that erode state-level search and seizure standards or other surveillance controls. Without robust human rights safeguards, foreign states are increasingly able to leverage legal cooperation procedures in rights-respecting countries in order to engage in acts of transnational repression. And new data sharing frameworks that are being negotiated and developed or proposed will likely see expanding shadow networks for the sharing of data obtained from particularly controversial sources, such as mercenary spyware, thus undermining the power of accountability mechanisms through secrecy. Law enforcement agencies, including in the context of C-2 or government officials that promote new powers, often state that since crime is increasingly happening across borders, that police agencies need to be able to move across borders as well. But what this framing typically leaves out is that human rights safeguards will also then need to be equally meaningful across borders as well. The reality, however, is that these cooperation mechanisms and negotiated powers are being developed in ways that prioritize law enforcement access while leaving individuals and communities in a remedial vacuum without meaningful protections, accountability or oversight mechanisms, or access to remedies. Rights are essentially falling through the cracks of national borders. And that
Sorry,
issue
Kate.
is
Oh, I don't mean to interrupt you. Just people are having a little trouble hearing you. I don't know if you can move your mic a little bit closer. Sorry for interrupting.
yes, I should be able to increase my volume. Oh yes, my input volume was very low. I apologize. Hopefully this is an improvement. So this issue is now upon us in Canada, as we know that Canada is considering and negotiating a data sharing agreement with the United States under a framework that's referred to as the Cloud Act in the United States, and that negotiation has been ongoing for a couple of years now. C-2 would make such an agreement more likely. As the Electronic Frontier Foundation has put it, the legislation is a roadmap to aligning Canadian surveillance with US demands in light of historical and very meaningful differences between the constitutional frameworks in both countries. In response to questions at a briefing on C-2 by government officials earlier this summer, those officials acknowledged to persons present that the intent of some of the provisions in C-2 is to enable Canada to implement and ratify another new, what I would describe as highly controversial data sharing treaty, publicly known as the Second Additional Protocol. And the briefing acknowledged that other cooperation tools with foreign states were foreseeable. Even leaving aside the potential for new controversial agreements with the United States or other states, C-2 would significantly expand law enforcement surveillance powers by eliminating or watering down existing protections in Canadian law. Some of these new powers include powers that are framed as warrantless search and seizure powers to collect information that is in the quote unquote public domain, or from entities that are providing information voluntarily to the police. However, these catchphrases are reflective of years of controversial and well-litigated fights in Canadian courts that have noted that such powers are highly controversial and impactful for individual rights. And if these powers as proposed are passed, they would open the floodgates to a wide array of data mining practices, including the collection of data from commercial data brokers, potential biometric surveillance systems, and other data-fueled AI and algorithmic surveillance systems, including technologies that have been studied as being non-compliant with Canadian privacy laws by the Privacy Commissioner of Canada. And this comes notwithstanding the absence of any meaningful safeguards around the use of algorithmic policing technologies or other AI tools at the federal level. Other experts have analyzed C-2 as raising new proposed powers that are zombie-like proposals from previous failed attempts by past governments to create warrantless or less protective access to sensitive data like subscriber information, which when amassed and analyzed can portray highly revealing patterns of individual online activity or in real life activity that the Supreme Court has said warrant protections because of the significant privacy interests engaged. We have as well a new order-making regime in Part 15 of the bill that proposes government powers to force electronic service providers to install surveillance capabilities and backdoors. This can lead to the compelled data retention by service providers in ways that create corresponding cybersecurity risks for individuals using those services. as well as facilitating surveillance orders to access data from a range of services, including email, phone, cloud storage, VPNs, or messaging apps. These surveillance capability regimes inevitably create security vulnerabilities. And despite these very significant risks, there are extensive secrecy powers accompanying this regime and a lack of judicial oversight. Where there are measures to challenge, they are available only to companies themselves, not the individuals that use these services. This is reflective of a US-style approach where companies are often seen as holding the keys to information between the state and the individuals who have information and the power of those companies. But in Canada, courts have been clear that third parties like electronic service providers don't have this authority to volunteer or not protect information that they hold on behalf of their customers. Due process rights here in Canada need to reflect that, including the need for judicial oversight, which is not present at all in Part 15. We know earlier this year, that a Canadian official has advised a journalist that the USA is placing pressure on the Canadian government to pass C-2 in order to enable the same type of toolkit that US counterparts have under controversial laws like the Patriot Act and FISA. And these negotiations under the Cloud Act could very well lead to, quite literally, Canada ceding sovereignty, which is quite specifically what is at stake in a cloud agreement. If Canada were to agree to this arrangement, it would give US authorities direct access to issue orders on Canadian entities, public and private. And it would mean that the Canadian courts, which protect Canada's constitutional rights, would have no role in overseeing that form of surveillance. There are very long-standing protections in Canada that are meaningfully different from the United States. And while we share a lot by way of proximity geographically and culturally and in many other ways, there are also really significant ways in which Canada has charted its own course and is going back as far as the 1990s, when Canada's Supreme Court observed what the American courts were doing and looked forward at how technology was changing and said that that's not an approach that works for us under our charter. And if we're going to have a meaningful measure of protection and security from unreasonable surveillance practices, we have to recognize that information that we share with electronic service providers or other persons is still meaningfully protected when it comes to state surveillance. And this is an approach, when you think about how our day-to-day lives work now, where we have smartphones that are quite literally full of third parties that we're technically and mechanistically sharing information with because they're providing us with digital services. That doesn't mean that we've conceded our privacy rights when it comes to the democratic controls that the Constitution enables to protect civil liberties. And this shift has a shift in approach. It really comes from our willingness to take a deep breath and say, we're doing something differently, and that police powers don't require unprecedented scope, that judicial oversight is still compatible with our meaningful ability to protect public safety and to meaningfully prosecute those who are responsible for wrongdoing. And we're actually a good example of a country that has shown that this model is possible. And so I think that this difference in approach is a significant one. It's been one that would be frankly shattered if Canada were to introduce some of these shifts, which take the form of statutory powers that can read in a sort of anodyne way when we're looking at the legislation, but they're actually engaging some of the very core of our protections in Canada that we've benefited from for decades. It's not only a matter of civil liberties and democratic controls, it's also increasingly a matter of cybersecurity. The US lacks comprehensive privacy legislation, and I think that it's not a coincidence that some reports have described that individuals in the USA are reportedly far more likely, by one measure, 700% more likely to be the target of cyber fraud than the people in Canada. And so we see that not only have these privacy protective stances worked from a democratic perspective and led to more resilience to technological change in Canada. Protecting privacy is also about protecting our vital infrastructure and our personal information from all forms of malicious actors. We're also, unfortunately, seeing a rise around the world of digital authoritarianism that has coincided with practices around and patterns around foreign interference and transnational repression that Canada has an unfortunate and difficult history with, but where we can see examples of cooperation tools that have lacked human rights obligations, such as those facilitated by Interpol, where we can learn from those lessons and ensure that we continue to take our own Made in Canada approach. And but I would emphasize, however, that the powers in C-2, regardless of what agreements may be put in place over time, because not all of those agreements are inevitable, no doubt, but even on its own, it would introduce American-style surveillance practices that have, for a very long time, been understood to be protected against in Canada through important controls. And we are a country that has not been perfect ourselves. We have our own history with surveillance scandals or abuses, if I can put it that way. In Quebec alone, there have been inquiries around the history of illegal surveillance, for example, of political organization and speech in Quebec is an example. And some of the protections that are at stake now are some that are introduced in the wake of those revelations even decades ago. And so I'd really encourage us to think about the privacy impacts of these powers, not only for how Canada can exist as a leader of human rights around the world, but also how we need to maintain our protections that have only served democracy and free speech and civil liberties in Canada at home on our own terms. So thanks so much for those for your attention, and I'm really happy to answer any more questions that you may have in the rest of the panel.
Thanks so much, Kate. That was really informative and definitely clarifies a lot of the problems around privacy and police powers in Bill C-2. There's a lot of questions in the chat that I'm sure we'll be able to get to, and thanks to our other invited experts who have been diligently answering questions in the Q&A box and following up on chat and all the energy that's there. Keep the questions definitely coming, and we'll have time for more later on. We're planning to wrap up around 8:30, but we'll see how much time we have to get to the Q&A, and maybe if everyone's okay, we can stay on a little bit longer. But now we'll move on to our next guest speaker, who is Matt Hatfield. Let me just share this. Matt is... Hi, Matt. Matt is the Executive Director at OpenMedia, a grassroots community of more than 300,000 people in Canada and the US who collaborate to defend democracy and keep our internet accessible, open, and surveillance-free. Matt holds a master's degree of global affairs from the University of Toronto, and prior to joining OpenMedia, worked defending global online freedom of expression with the IFEX network. Matt will be sharing with us ways that we can, organize and mobilize to fight back against Bill C-2 and call for its full withdrawal. So with that, I'll leave it to you, Matt.
Yeah, so thanks everyone. You have heard a lot of technical detail. You've heard a lot of scary facts about this bill. And I am hoping to be brief and to leave you with some hope and to talk about your role in all this, and a bit of fire too, on how we're going to stop this bill. You know, the world trains us to think that no one is listening to us and that our opinion isn't worth anything. And I need you to know that when you reach out to your, oh, I'm quiet. Okay, I'm going to try to turn that up. How am I coming through now? Is that better? I think it's better. Okay, great. Thanks for flagging, Valerie. Yes, so when you speak to your local MP, your voice matters immensely. I know that, and I know that because no one would speak to me ever if it was just me going out on behalf of OpenMedia. They pay attention to us, and they're frankly afraid of us, afraid of your anger, because of you. Because when they get the hundreds of emails, thousands of emails that you folks send in, when they get dozens of constituents calling them, they know that that's not representing just those people, that every 10 constituents who call them represents 100 or 1,000 constituents who care about this. And that really swings their perspective. They are there to represent you. A lot of them are elected by margins of a few hundred voters. When they realize that there's 500 people in their community that are really fired up about this and are telling them, I won't vote for you if you support this bill, they change their mind pretty fast. And well, today's another day to try, Terry. You can always speak to the staff at least. You know, you may find that some MP staff are actually kind of sympathetic towards you. You may find that they just repeat the party line and it feels like you're talking to a wall. Even if you feel like you're talking to a wall, a wall, it still makes a difference. You know, even if the party is saying, we love C-2, we're gonna do this bill, they're counting those emails. They are taking those emails to caucus and they are saying, it seems like this bill's not actually a winner with the public. It seems like this is a big problem for us. We need to reconsider. Every MP is always doing calculus about what's popular with you and your neighbors. They're thinking about what affects their personal chance of being reelected and their party's chance of reelection. And some of them probably already do agree with you, and they just need to hear from enough people to speak up. But even for the ones who don't, they are doing that math, and you can shift that math in their heads. So we're going to go to the next slide and talk about a theory of change. That's right, Elizabeth. That's right. So some people read them. A lot of people don't. So what's the theory of change on how we're going to win here? There's two paths to stopping this bill. It's a minority parliament, and so one path to completely stopping C-2 is if we can get every single opposition party to fully oppose the bill and vote it down. So that means the NDP and the Greens, it means the Bloc and the Conservatives as well. The good news on that is that every party has raised some serious concerns with C-2. No one has said we love the bill as a whole, besides the Liberals. The bad news is that I think there's a pretty good chance some parties are willing to bend, at least right now, and might, with amendments, pass the bill. So that's going to be the harder path for us here. The potentially, I think, more fruitful path is we need to convince the Liberal backbenchers that this is incredibly poisonous for their party and that they should not pass it. It's going to hurt their standing with a lot of Liberal voters. And the advantage of that position is that it's true. I think very few people who voted for Mark Carney thought they were voting for a bill like this. People have called it a bill that Trump might pass, that Paliev might pass. It's certainly not a bill that people expected from the Liberal Party. And so we would like to see you contact your MP no matter which party they're from. And I want to go over the party landscape a little bit with you on the next slide. So here's some key politicians to be aware of. And I've kind of separated them mentally into three groups. There's the Liberals there on the right. There's the minister who proposed this legislation, that's Gary. And Gary, maybe a little too honest for his own good. If you do a quick Google, you'll find Gary told the public, you know, a big part of this bill is about getting rid of irritants to the US. Well, I would say that our privacy and our values, those should be irritants to this American administration. We need to stand up for those. And I think a lot of Liberal backbenchers in their heart of hearts would say the same. So when you call your Liberal MP, when you write to them, call them out for this. Call them to be responsible to their values. There's of course Carney, who I don't know if this is his idea or if he got fooled by some people from public safety, some longtime security establishment people. But currently he's supporting the bill. He needs to know that this is a huge stain on his legacy. This cannot be how he opens it as the very second bill that they've proposed. And then of course there's Lena. You know, she's the minister directly responsible for immigration, refugees, and citizenship. She needs to hear how incredibly unpopular this is with the public. They think that after some of the border issues that Canada's had and the fake border issues that the US has invented, Some people in the public are supportive of this kind of legislation. They need to hear from you that we're not. So that's the Liberals. At the bottom there, you'll see Jenny and Elizabeth May. So the NDP and the Greens have both come out fully opposed to this bill, and that's great. And even if you're in one of the ridings represented by the NDP or Greens, still call them, tell you what you think, tell them that you want them not just opposing Bill C-2, but talking about Bill C-2 with all the time they get in Parliament, throwing monkey wrenches in the gears of any kind of parliamentary procedure they can around this bill, talking to media about it. Tell them this is one of the most important issues for their voters, and that you're likely to make a voting decision towards the party that upholds a strong defense here. And it's Jenny is a leader here, and it's certainly not just her. We've heard great statements from other NDP leaders as well. Oh, something seems to have happened to the slides there, Tim. Now there's a final group of people that some of you might not be voters for, but if you're in the ridings of these folk, I want you to contact them anyway. I'm talking about the Bloc, and I'm talking about the Conservatives. So, like I said earlier, the good news is both of these parties have said they have quite serious issues with parts of Bill C-2. They've both said, well, some of the border and migration stuff we think is maybe good. We could be convinced to support it. I know many people here would not agree with that, but nonetheless, they have said we have serious concerns with the privacy side and with some of the overreaching in this bill. If you're in one of these ridings, you need to contact them and talk to them as well. If there's a possibility that you would ever consider voting for them, tell them that, and tell them that this bill will remove that possibility for good. Whether it is or not, though, just tell them that you are going to be talking to everyone in the riding all the time about this bill, how destructive it is, and that they are one of the parties who hasn't come out fully opposed to it. Again, like, they might not say, we're going to listen to you and we're going to change here in the moment. But they're making note of this. Like Elizabeth said, they're adding up spreadsheets, they're bringing it to their caucus. This will have a long-term impact on how these parties position themselves. So I think we're going to go to the next slide now, Tim. So let's talk about how to have an impact. Contact your MP. Do it today. Do it at the end of this hearing. Do it during the Q&A. And don't just do it today. I think what MPs hope for and what Carney is hoping for is, hey, this is briefly controversial. There's some bad news headlines this week, and then it goes away. It's on to the next thing. It's on to what the Trump administration is doing or whatever. We can keep that from happening. We can keep it in the news every single day and every week. And it will happen because you keep up the drumbeat of writing, use one action today, use a different action in a couple days from now, use a third action next week. You can take an action more than once. It's like, don't lie and say you're a different person, but just say you're writing again. This is still important to you. And we've got a great call tool that our friends at the Migrant Rights Network have put together, which we're going to introduce you to at the end of this call. If you haven't used a call tool before, it's like an email tool, but instead of sending in a scripted message, we give you some talking points, and you can get directly connected to the offices of the Immigration Minister, Public Safety Minister, and MP. The call tool will sort of roll through them in order and give you a chance to leave a message with each of them. I think you'll find that many of their offices are closed, but you can leave a message explaining your position and why you care about this. Use some of our talking points and use your own words. Convey your passion and talk to them about why this is so important to you. So there's contacting your MP, and there's talking to people about Bill C-2. We're in an era where it feels like all of life has moved online. We do a lot of our work here at OpenMedia online. Do not let this be just an online thing. If there are people in your life who don't know about Bill C-2, you need to talk to them about it. Find a way of connecting it to things they care about. Tell them they need to take action. Link them to one of the actions that are available that speaks to you, and get them to join on board. We've got, 300 people here? I did some math before this. If each person here got just 2 people to send in their views on C-2 to the government, I think it's about 10 or 11 hops, we'd have 1 million people putting in their views. And at that point, that is incredibly hard for even this government to push forward without major changes or without dropping the legislation. So that's my little pep talk. I truly believe that we can do this. We can stop this legislation. We've done it before and it'll happen again. But it's going to take some work, and we need all of you pulling with us. So I'm going to pass on to Sarom, who's going to talk a little bit about the call tool.
Thanks, Matt. So as you said, this tool directly connects you to the public safety minister, to the immigration minister, as well as your local MP. And so I'll walk you through it. And I want to also note that our power, we must hold elected officials to account to say that we don't want egregious bills like this. We don't want a rollback of democratic rights, and we certainly don't want the collective punishment of migrants, undocumented people, and refugees. But in order to also stop the entire Carney agenda and also the other kinds of enforcement infrastructure that will be built by the passing of bills like Bill C-2, we need to unite as people. And so join an action near you for September 20th, and also join an organization, join constituency groups, and really build the links with the people who are going to do this with you, and entrust the power in the collective and not only on the elected officials who time and time again have failed. But the tool is a great way to also start that conversation with people in your neighborhood or your workplace, or with family members. So we're going to drop the link in the chat, but it's very simple. How it works is you'll see this page come up, and you put in your name. So I'm going to do that right now. I'm going to put in my phone number, and then I will get a call on my phone that will connect me. I'm going to put in my postal code so that it can identify who my member of parliament is, which is MP Chrystia Freeland. And then I'm going to hit the button, make the call. And then this these talking points that Matt mentioned will come up, and some of them that we are suggesting for the full withdrawal of this bill are around impacts on migrant and refugee rights, on privacy, on survivors, on medically vulnerable people. And you can lean in and talk about your personal passion about why you're against Bill C-2 and why you want it to be withdrawn, so that you can also share your own stories. Perhaps there's someone in your life who is who will be directly impacted by this. Maybe you're worried for yourself, and the more personal you make it, particularly with your member of parliament, the better. So soon I'll be getting a call on my phone that will directly connect me through. After I leave one message, it'll connect me to the next one, and so forth. But if you don't get a call on the phone for some reason, sometimes the tool is being used too much, on our website there are also the phone numbers of the Public Safety Minister and Immigration Minister, as well as a link to find the number of your local member of parliament. I just want to urge you that there's going to be a cabinet retreat next on the weekend of the 6th and the 7th. And so now is really the time to be making these calls and making sure that the ministers and members of parliament really hear us, and that there is broad opposition to this bill. And as Matt said, even if it gets even if it passes, I mean, hopefully we'll be able to stop it, but even if it passes in some way or form, because it will go to committee, and this committee is controlled by the Liberals and Conservatives, there is still so much hope, still so much momentum for us to fight this bill and really be building the community infrastructure that we need to take on any other attacks that will come our way on any of our communities. I'll pass it back.
Thanks so much, Sarom, and thanks so much, Matt, for lighting that fire, getting us all ready to make some calls, send some letters, reach out to our MPs, talk to people in our kitchens, in our neighborhoods, at events that we go to really drive home the concerns around Bill C-2 and how we can all speak up against it. Sarom, if I can ask for you to maybe share the link to the call tool again in the chat. There's been a couple questions. A call tool hasn't been translated yet, but I think that's something that we can look into over the next few days. And yes, all the links to actions have been shared in the chat today, and that Matt and Sarom have mentioned are going to be sent out in an email follow-up to everyone who's registered tonight. So all of you will be receiving that. You can look in the chat now. Sarom has shared the link. We're going to encourage everyone to start making calls, but in the meantime as well, so that we don't lose momentum and use the time that we have, We're going to go to the Q&A as well right now. We'll also leave this open for a little while after the Q&A so that folks can still have access to that link and keep making calls tonight. But definitely copy it, email it to people you know, share it with folks, and keep the calls going over the next few days. As Sarom mentioned, the key dates there of, I think it was the 6th and 7th of September that the Liberal Party is having their caucus retreat. And C-2 will be a topic of discussion there, and it'll be really key to put pressure on Liberal backbenchers to bring this up, to put pressure on the rest of the government to know that there's outcry around Bill C-2. So with all that said, now we'll move on to the Q&A. So maybe if we can bring all our panelists back up on the screen and our invited guest experts. Again, if folks have questions, please put them in the Q&A box or in the chat, and we'll do our best job to get to those. You know, and I just want to emphasize here that we have folks who are joining us who are experts on the topics that we've heard tonight, but also, for example, Debbie from Action Canada for Sexual Health and Rights can cover other topics, and definitely any question that you have about the impacts of this bill, we'll do our best to answer. Also, if there's questions that we can't answer, we can look into them and also send it out as part of that package later on when we send out all the links and the link to the live stream. So yeah, I'll see if there's any questions. If others have any questions they want to pass, any of our co-moderators have questions to pass along. A lot of the questions in the Q&A have already been asked, but maybe we'll see if anyone else asks this kind of question. But just to kick things off, somebody asked, I have never participated in any initiative like this. How successful are they in actually affecting what Parliament does and changing Bill C-2? So I think that's a really key question to why we're here tonight. We want to affect change. We want to stop Bill C-2. So I wonder if any of the folks here can maybe speak to, the effectiveness and how we can, keep the momentum going and push for change. Matt, I saw you put your hand up. Yeah, go ahead.
Yeah, government hates to say we were going to do something really bad, and then we faced a lot of criticism and pressure, and so we changed our mind. That's really embarrassing for them to admit, but it does happen. I can tell you it happens. So there's different ways in which us winning here might look. One way that it might look would be that Bill C-2 just sort of fails to move forward at committee. It gets delayed, it gets pushed for other things. Gradually, it just sort of falls off the agenda, rather than Mark Carney is not going to come out and apologize to us for this horrible bill. But there's been a lot of bills that we have seen that kind of success on. Last year or the year before, it might have been Bill S-210 was a really poorly drafted age verification bill that we got exactly that. The government never came out and said, oh, we're not doing this. No party actually voted against it besides the Liberals. It had been pushed forward by the opposition parties, but it just gradually fell off the agenda. And so that was a way for them to tacitly acknowledge they'd lost without coming out and telling us, hey, people power won this thing.
Thanks, Matt. Would anyone else like to jump in or have any thoughts they want to share on that? Go ahead, Sarom.
Exactly. There have been so many ways that we have been able to stop bad policies from coming into play, and also build up, and even when they do come into play, to build up the kind of infrastructure we need to make sure that those who are particularly targeted can be protected, right? There is no, we can use that word again, no, to say there is no such thing as fait accompli. Right? Nothing is done, right? We can always create another road by walking it together, but it means that we need many of us to walk it together. And so the tool is one way that we can have those conversations with people, because again, Bill C-2 is coming from 2 years of particularly bad anti-migrant policies, but also decades of an immigration system in Canada that is increasingly what the United Nations has called a breeding ground for contemporary slavery, right? Bill C-2 is one part of a larger set of forces at play that are going against many of our rights. And so, again, even if we are not able to stop this bill, there's always hope. And it means that it shouldn't stop us from trying, right? And, as Matt said, we can do it, right? As long as we try. Because what else are we going to do? Are we going to sit back and let this happen? No, right?
If I can jump in as
Go
well.
ahead. Yeah.
On it, there was a similar type of on the refugee ineligibility side. In the 2019 budget, the Liberals, then with a majority government, introduced the Five Eyes ineligibility, and then through engagement by civil society, engagement with Liberal MPs, the bill wasn't withdrawn, but that's why those individuals have mandatory hearings. And it was the Liberals in the Citizenship and Immigration Committee who introduced the amendments to provide more procedural protections for those individuals who had made claims in other Five Eyes countries. And so even if a bill is not withdrawn, and we all share the view that the bill should be withdrawn, but if it's not, putting forward ideas explaining what the government might have missed can lead to amendments in committee, and that's all the more so in a minority government.
Thanks, Adam. Anyone else want to jump in on that? Okay, maybe I'll just emphasize that last point that Adam made about how this is a minority government. And we've seen success in the past, both fighting back against bills, but also minority governments don't last forever. Sometimes they get bogged down in all kinds of procedural issues and things get slowed down. And so part of what we're able to also do is to make sure that we're raising these concerns, make sure that committee hearings aren't rushed and that they're drawn out, that there's questions asked in Parliament, that once it gets to the Senate, which is more unpredictable because they aren't necessarily party caucuses and they are not whipped, that we make sure that there are long hearings and questions asked so that that can also be a way of both, if necessary, bringing changes, but ideally, and still the main focus is stopping the bill in its tracks by, for example, drawing it out until the end of the minority government. It's not a guarantee, but it's something that we can keep in mind as we're pushing forward on the bill. Yeah, I don't have any new questions in the chat, but there's one that came up in the Q&A quite a few times. And it was primarily to get some more clarification. And I think people are really interested around what this 1-year timeline for refugee claimants means and how it will operate. I think if anyone wants to jump in, either Adam or I think Aisling had kind of shared some other thoughts on it in the chat. If either of you want to jump in and maybe kind of reiterate exactly what that 1-year timeline means and how it'll be implemented. I think there's maybe some questions around what that cutoff of June 2020 represents and some of those questions. So yeah, just invite you to maybe clarify that some more.
I'm happy. Aisling, I'm happy to.
Go ahead, Adam.
Sure. So there's a couple of timelines that apply within the bill. The first is this 1-year cutoff. So as the way the bill foresees this working, if someone came to Canada at any point after June 2020, sorry, I don't have the exact date in front of me, and then they make a claim 1 year or more after they arrived for the first time, they are then ineligible to go through the full refugee process. If they came before June 2020, they're okay. But if they came at any point after June 2020, even if they left and came back, they're ineligible. The retroactivity part of this bill means that even though it hasn't passed, once it goes into force, it applies to any claim made after June 20th or so of this year. So if someone made a claim today, but they had been in Canada or had first come to Canada more than a year before today, they are ineligible. Hoping that that maybe clarifies some of the questions. There may have been more in there, Tim.
I think there's also some questions about to what degree people who are applying for refugee status right now may be affected, in this period between the bill being introduced and the bill, and if
Yes.
hopefully not, but if the bill is adopted, what that impact will be.
Yeah. So people applying now, based on how the bill is drafted, if it's adopted in exactly the way that it's drafted now, someone who made a claim in Canada since June 20th or so of this year, if they had been in Canada for more than a year already, they're going to get retroactively, their claim is going to be found ineligible retroactively. And the minister has the power to find a claim ineligible and terminate a claim at the Refugee Protection Division of the Immigration and Refugee Board up until the point that a hearing happens.
Thanks, Adam. I think that helps a lot. I hope that clarifies it for folks, and definitely follow up with us if you have any other further questions. Thanks to everyone who's saying that they're making calls. I know that for some people it might not be going through for the second or third call, but I encourage you to keep trying. And I think we're going to be looking into that question of the follow-up calls as well. Something else we wanted to touch on is questions around what C-2 means for access to health information. And so I don't know if Kate or others would want to maybe speak specifically to what does C-2 automatically provide, or are there other provide access to requesting information from healthcare providers, and what that means. Maybe Kate or Debbie could speak to that.
So I'd answer that question in a few ways. There are new powers in the bill that have been widely criticized in the months since the legislation was tabled, because it would create a warrantless demand power to ask service providers whether an individual who is receiving services from a particular electronic service provider or in-person community-based service. There are inadequate protections around this new power, and it facially raises numerous constitutional problems, mindful of the nature of the information and how sensitive it can be. There are also reduced protections around access to subscriber information, which creates even more of a picture about who an individual is, perhaps behind an anonymous digital tool, and other types of account information that could be accessed under a lower threshold now, despite it being inordinately sensitive information that carries significant privacy interests according to Canadian law, which is why both of those powers have been criticized as constitutionally suspect, to say the least. But I would also urge to consider the data mining powers that are essentially brought in by way of unspoken subtext. It's not explicit language that's in the legislation, but when it talks about warrantless access to information in the public domain, it is well known that in other cases where there have been powers about accessing publicly available information, that has been interpreted and can be interpreted as it including the ability to purchase information from data brokers. And there's a very widespread problem about the extent to which individuals' health concerns, health services, and sort of adjacent digital services that are maybe not captured directly by health care oriented legislation, but nevertheless carries all of the exact same concerns. The amount of information that we have in the wake of our online activity often creates that eerie feeling when you get targeted advertising and information appears to be operating in the background about what types of things might be on our minds, our psychological concerns, our health concerns. And that information, unfortunately, is now in jeopardy when it comes to government surveillance. While many individuals do find that to be very eerie when they're a recipient of targeted advertising, they still do not expect that the government to be harvesting that information and integrating it into its surveillance and analytics tools. And that's what these publicly available new powers would endanger.
Thanks so much, Kate. Really appreciate that clarification. And yeah, Debbie, I don't know if you have anything to add, or also if you could speak just more generally to the concerns around this bill around sexual rights and reproductive health.
Absolutely. Thank you so much for the opportunity to share a little bit about this from the perspective of someone who works at a reproductive justice and sexual health organization. Kate provided a really good overview of the powers this bill does give in the context of healthcare information. For those who work in sexual health, including on the front lines, where this becomes particularly interesting in a concerning way, and what I want to just echo with the folks who are in this room, is that abortion access in this country still remains a significant challenge for many people. And where it is a big challenge are for those who are uninsured. And people who are uninsured are often newcomers, precariously status, and also are refugees. And as a result of that, what this bill creates is an environment where those who are supporting people to access an abortion, and this could also include folks that I work with at Action Canada, because we do have frontline services. It also includes the network of sexual health centers that are partnered with us, but also so many other reproductive oriented organizations who are supporting people who do not have health insurance in the province of Ontario that I live in, but also many provinces and territories around the country. And so what's really key is that this bill puts people who are already vulnerable by virtue of not being able to have adequate sexual health care access at risk of having information of theirs, including if they've accessed an abortion or anything else related to their reproductive health care, be provided to the state if the state demands it. And for the people who are working in this field, who already have to deal with the stigma associated with sexual and reproductive health and rights, it presents that extra challenge where now people who just want people to access healthcare are put in the position of being border agents in a way. And so I name this to give folks some context. And if you have any questions at all, please feel free to reach out to me. I'll add my email in the chat. This is something that we will be talking to other gender justice organizations about to ensure that that is a lens that they're keeping in mind as we're thinking about how this intersects with so many different sectors, so that we can build and mobilize more attention on this to ensure that this bill doesn't move forward, especially in its current iteration.
Thanks so much for that, Debbie. Really appreciate you adding that context to everything we've talked about tonight, and definitely hope folks can reach out to you with any further questions. We're past 8:30, so I think that was around the time we were going to wrap up. If there are any outstanding questions, we're going to go through them and we can answer them in the follow-up email that we send. But I think we'll wrap things up for now. But I will, again, encourage people to keep sending their messages. Keep calling, and we'll be in touch in the next few days with follow-up from tonight's call. I want to thank again the hundreds of people who joined the call tonight. A huge thank you to our speakers, Sarom, Adam Sadinsky, Kate Robertson, and Matt Hatfield, and really to our invited experts who have been doing work in the chat and all throughout the night. Debbie Owosuecha, Ashlyn Jackson, Aisling Bondi, and Julia Sand. I'd also really like to thank the folks who've been working behind the scenes who helped make this happen tonight. Caitlin Thomas, Jen McIntyre, Amy Kasapuli, Zan Dajane, Sayed Hassan, and Karen Koch. Really thank you for being able to put together tonight's wonderful and really informative and I'd say really energizing webinar. So we'll keep the chat open a little bit longer so that folks can still access the click to call your MP link. Maybe there's been a lot of links put in. Maybe we can add the click to call link again in the chat if somebody can put that in there. And as I said, we'll be sending a follow-up email with that link, the recording, and lots of other links to materials and letter writing campaigns. There's going to be more backgrounders coming out. Feel free to follow up with us. If you have any further questions, I'll put my email in the chat as well. And just thanks so much for everyone for being here, for connecting with us, and for being part of this movement to stop Bill C-2, which I'm sure we're going to do over the next weeks and months. So thanks so much, and have a great rest of your evenings.